I hope you enjoyed today's virtual event experience, and I'll now turn it over to our moderator. In addition to serving as an advisor to dealmakers, Charles Eldering is an inventor, entrepreneur, and the CEO of Case Analysis. You can find his bio along with our panelists' bios up top by clicking on the View Schedule link. It's all yours, Charles. Good luck.
Thank you,
guys, in a bit.
Thank you, Wendy. As always, it's a pleasure to be working with you here today at Dealmakers and part of this exciting panel. So let's get started. I would first like to introduce our panelists and speakers. We have with us today Elena Hammond, an investment manager at Validity Finance, where she utilizes her more than 16 years as a trial lawyer representing businesses and individuals in complex and energy litigation to evaluate and fund cases. We also have with us Christine Lehman, the managing partner of Reichman, Jorgensen, Lehman, and Feldberg. Christine is an accomplished trial attorney focusing on patent litigation in both the U.S. District Courts and the International Trade Commission. And finally, we're pleased to have with us Eric Eisenstein, who is the Vice President of Licensing Strategy for Personalized Media Communications, where he is responsible for analyzing markets, identifying opportunities, and negotiating transactions. Good afternoon and good morning to those of you. I don't think anyone's on the West Coast, but we're glad to have you with us. And I'd like to get started with a question to Elena. Elena, as a funder, I believe you are in a good position to see what's going on in the IP space with respect to demand for capital, slowdowns, and post-COVID induced change in general. Can you tell us what you're seeing?
Well, first, thanks so much, Charles, for moderating this panel, and thanks to Christine and Eric for being on the panel. I'm really excited to be part of this discussion. In response to your questions about what's going on in the IP space, at Validity, we see a lot of opportunities to fund patent cases, in addition to the other types of commercial cases that we fund. So it does, as you mentioned, give me a pretty good vantage point into the world of IP litigation. And what we're seeing is, well, first and foremost, a strong interest on the part of companies of all sizes and inventors to enforce their patent portfolios. From some companies, we've heard that the pandemic and the related slowdowns in certain parts of their business that resulted from the pandemic have prompted them to mine their patent portfolios, to take a fresh look at them and to dust them off and see if there's any enforcement or monetization that can be done. I think companies and inventors recognize that patent campaigns can be important revenue drivers, and boosting revenue, of course, is the name of the game. So that's first. Along with the interest in patent campaigns that we're also seeing an increased demand in funding for patent cases. We have seen an increase in our patent portfolios year over year, and that trend seems to continue to grow. At Validity, we try to keep our overall investment portfolio around 25 to 30% patent. So the more opportunities that we're seeing in the patent space means the more selective that we have to be about the cases that we fund to maintain that concentration. In terms of who's bringing us these opportunities, we're getting funding inquiries from single inventors, small companies, and even large corporations. Anyone who holds patents is looking to monetize and often looking to fund that litigation. We see a lot in the tech space, of course, but also in oil and gas and other business sectors. One thing that's common to most of the patent opportunities that we see is almost everyone wants to be in Texas. Texas is a very hot venue, either in the Eastern District of Texas or the Western District of Texas, which I think has been dubbed the busiest patent venue in the country. Sometimes the Southern District of Texas is on people's list, but mostly we're seeing Eastern and Western. And this is in line with statistics that I've seen for those courts. Patent cases, as I understand, have stayed fairly consistent since the pandemic. I have stats that 416 patent cases were filed in the Eastern District during the peak of the pandemic, that March 20 to 21 period. So that's 416, and about 308 were filed the previous year during that same period. So a little bump. But where we're seeing this incredible jump is in the Western District of Texas. Recall Judge Albright took the bench at the end of 2018, and in the year before the pandemic, so that's like early 2019 to early 2020, there were 257 patent cases filed in the Western District. But by contrast, the next year, during the peak pandemic time, March 2020 to March 2021, there were 876 patent cases filed there. That's more than 3 times as many cases. So people are really finding out about it. They're intrigued by Judge Albright, and I think we're going to talk about that more later in the panel. But that's definitely a trend we're seeing. Delaware seems to be another popular venue, and we're still seeing patent cases litigated in California and elsewhere. In terms of your question about the impact of COVID on the patent space, from our point of view as a funder, the most significant impact has been the delays that we've seen in the courts. As we probably all saw, some federal courts were able to keep the wheels turning better than others. Some were really efficient at using Zoom and telephonic hearings to make sure that they kept their docket moving. And some got back to in-person trials quicker than others. Some not so much. But I think across the board, the federal courts experienced a backlog, and they're all trying to kind of climb out of that now as they're finally getting back to regular business. So in the absence of trial settings for nearly a year, it's had a huge impact on plaintiffs' ability to get their cases settled. And that's in patent cases and other types of cases. It's really impacting all types of litigation. And my sense is that just without the pressure of a looming trial setting, the defendants are just not feeling that pressure. They're less likely to make meaningful settlement offers to try to get the case resolved. And so what this means from a funder's perspective is we're not seeing recoveries come in the timeframes that we expected. We are seeing some substantial recoveries, including some patent cases, but generally cases are pending longer. So that's been the biggest impact.
Well, Leda, thank you for that overview. I will comment one thing, and then I'll see if any other panelists want to comment, and that is there has been the suggestion that the pandemic allowed corporations and patent professionals a lot of time to sit down and focus on the assets and to see where the infringements were, and which we spent a fair amount of time doing during the quarantine. Do any other panelists want to comment on this big picture view that Lena has shown some light on?
Sure, I'll chime in. I would say the other forum that we've seen a lot of interest in, certainly Texas has been very, very popular in the patent cases, but also the International Trade Commission has seen a big uptick in cases since the pandemic because they were able to move to, they actually use a WebEx platform and have virtual trials without really skipping a beat. They had sort of a couple months while they sort of tried to figure out the kinks and set one up, but they have really caught up from an initial backlog that they had from the beginning of the pandemic and have been moving cases around. And certainly not every case can be filed there, but many of them can. So we're getting a lot of interest from clients about, if we can't do Texas because of TC Heartland or other concerns, is the ITC a possibility?
Well, Christine, I'd like to hear more about your perspective on how this has impacted your clients, but let me go to a specific question that you raised something interesting. If an entity, a patent holder, is looking at Texas versus ITC, two different remedies in general. I guess you can certainly get an injunction in Texas if you're, or it's possible, but most parties are looking for a monetary award, whereas the ITC, it's only injunction. So how does that weigh into that decision?
While the ITC only gives an injunction, an exclusion order as a remedy, we often see people file kind of a district court case in parallel with it that is stayed pending the outcome of the ITC. But I mean, if the goal is an ultimate settlement, a ITC exclusion order is certainly going to drive those discussions to a settlement pretty darn quickly. So,
okay. Can you share some more perspectives on how this is impacting, in particular, patent holders versus accused infringers?
Well, I would definitely, echo Elena's comments. We've also seen just patent holders, a whole range from the large companies to the individual inventors coming to us and saying like, okay, this is the time. We've actually sat down, looked at this, had a chance to study it. So we've definitely seen an uptick in that, and not being able to have those trial dates has definitely, I think, cut down on those settlements that need the trial date to stick. So I think that has been a disadvantage for patent holders. But at the same time, we've been really impressed how quickly judges and courts are just, climbing out and holding trials and setting trial dates. I think it's going to be an incredibly busy, third and fourth quarter of 2021 for trials.
When do you think the backlog could be cleared?
Well, it depends on the court, I would say, but...
Well, pick Delaware if I was going to be specific. Well, how about Delaware? Well, we know Texas is moving as fast as they can, and probably just build more courtrooms if they have to. But
Right. I think Delaware is picking up, and certainly they made good use of video hearings and telephone hearings to keep up with their docket in every way, just to move cases along in every other way. To the extent they could do Markman hearings and summary judgment hearings, they did lots of other hearings to keep the cases on track. I think Delaware is still backed up from the initial TC Heartland boost, because of course a couple of years ago we were all talking about how TC Heartland, was going to rapidly shifted all the cases out of Texas to Delaware and California, but somehow people have still found a way to file a lot of cases in Texas this year.
Yeah. Does anyone else want to comment on what Christine is observing as a litigator?
Well, I'll just say from the standpoint of a patent owner, when your whole business is about monetizing your patents, then clearly the delay that unfortunately has been caused by COVID was kind of a bluebird for companies that are alleged to have infringed. And if the model from their perspective is to ask for stays, to tie things up in motion practice, to delay the ultimate monetization or the ultimate resolution of a case as long as possible, then sadly, COVID was a hell of an opportunity. And it's going to take a while. Patent cases, rightly, come behind criminal cases, for example. And so federal courts are going to have quite a bit of things that they're going to have to work through before patent cases get much attention in some venues.
So Eric, would you say that, clearly we've heard that the delays have favored defendants or presumed infringers and delayed settlements. Would you say it's emboldened infringers also? Or were they already so bold? They were pretty bold.
I was going to say, the problem is that when you're at 10 on the scale, there's nowhere to go. There are so many reasons, from essentially free capital to the mismatch in how law firms get paid, to the delay factors, et cetera, that really, I don't know that it's necessarily emboldened them or made them, it's given a certain advantage, but no, I don't think that it was an increase, because like I say, the dial was already at 10.
So perhaps one way to look at it might be to say they already had such a strategic advantage, given the state of patent law. The delays are more of a tactical advantage in them not having to settle.
I think that's right. It's really more of the same, I guess, is probably the way to think about it. Yeah.
Well, I would say I just wanted to chime in there. The other forum, this delay has really been specific to jury trials, just because the jury trial had the biggest problems because of COVID, obviously, for all the reasons of having large groups of people in a small courtroom. because the other forum that hasn't been slowed down due to COVID has been the PTAB. And so, which has, does not have a particularly great reputation for helping patent owners. And so it really has kind of amplified the importance of watching those IPRs, because while a lot of district court cases might have been, whether maybe not explicitly stayed because of COVID, but had their trial dates pushed out, if you have a co-pending IPR, you end up in this sort of race for finality. And the PTAB was able to do their hearings because they're not in a jury trial. They were able to do their hearings remotely and largely stay on track, from what I understand.
Yes, that's and the PTAB has, of course, been no friend of the patent holder, but perhaps there's some consolation in their efficiency, is what I'm hearing you say. Any other comments on PTAB in post-COVID?
I would just concur with Christine that the delays in the trial court have a big impact on the PTAB's ability to complete an IPR before a trial setting in the court. And so I think the PTAB's more likely to institute, whereas maybe before, if they thought there was an impending trial setting, they would decline on that basis.
Interesting. Well, Eric, I'd like to come back to you. We've been hearing a lot about Texas, appears to be the preferred forum for patent enforcement, and is perhaps getting even more popular post-COVID. I know you've had some success here. I'm referring to the $309 million jury verdict against Apple that Personalized Media received in March of this year. Can you tell us a bit about your experience in Texas and how that forum is comparing to other forums?
I can. I mean, obviously, that was a good outcome for us. We've had 3 cases go to trial in East Texas against Zynga, against Google, and against Apple. And despite all of the perception that, every time you walk into Marshall, you walk out with a 9-figure check, we've actually had 2 results where the jury found that our patents were not infringed. So in a sense, we're 1 for 3 in Marshall, Texas. Now, that being said, we like the venue, and not just because of our recent victory, but because when you file a case in Marshall or when you file a case in the Western District, you've got predictability and you've got a set timeline that allows you to plan out your case. And that's really, really valuable, not least of which because if, for example, a litigant was working with a funder where there's a time component to both parties' returns, then being able to get to trial quickly is really, really valuable. So, even putting aside the obvious expertise that the judges in both of those districts have, just by virtue of their experience, both as in Judge Albright's case as a patent lawyer, but they've tried so many patent cases, they know what they're doing. And another federal district judge who sees a patent case every couple of years, it's going to be a different situation. So there's real value in being able to go to a district court where you can predict, you can plan, you can finance, and ultimately get a jury verdict. One way or the other. As a lifelong Texan, I can tell you that we're pretty fond of the Constitution, and it does have a 7th Amendment that says you get to have a jury trial. And so, I like that the judges here really do respect that. They really do. And you're going to get your day in court. It's fairly uncommon as compared to some other venues that the judge says, no, you didn't meet the hurdle to get into the courtroom and have a jury hear your claim. And in Texas, we value that. So it's a good place. By contrast, we also have a case pending in the Southern District of New York where, the case is on hold and I don't know when we're going to get to trial. Not just because it's on hold, but because I'm not aware whether the court has even reopened. And once they do, as I mentioned earlier, there are going to be criminal cases and all kinds of other cases that frankly take priority and should. But nonetheless, we're sitting here with a wasting asset in the form of a patent, and even putting aside the question of the almost de minimis pretrial interest, you want to get to court, and it's going to take a long time in that venue. So Texas is a good place to be, and I think honestly, if you are being genuine in your expressed desire for a cheaper and faster resolution of a case, the folks that make a big hullabaloo about the joy of the PTAB really ought to also be in favor of the Western and Eastern districts of Texas, and they typically are not. And I find those critiques to be a little bit disingenuous, frankly.
Well, Eric, certainly it raises a lot of questions. I have some questions, but let me, Christine, Elena, comments?
I guess I would comment that we are lumping the Eastern District and Western District together, but I think that they're viewed somewhat differently, at least right now, by the Federal Circuit. And that's something that we're thinking about when we're evaluating a case that's going to be filed or is pending before Judge Albright, is what is the Federal Circuit's temperature towards Judge Albright right now? And, he's gotten a few slaps on the wrist, I guess you would say, about holding motions to transfer too long in the Federal Circuit's view. Noticed he's been transferring a few more cases lately. I think he just transferred 2 out of the Western District, 1 to Delaware and 1 to California. So hopefully that's satisfying the gods at the Federal Circuit and keeping them off his case. But it's kind of a remains to be seen. We haven't seen a lot with what happens to verdicts coming out of his court. And whereas in the Eastern District, it's really a much more known quantity. And I think the Federal Circuit doesn't have any kind of particular animus towards Judge Gilstrap and Marshall, for example. So, but the main thing is, if you want to be in Texas, you have to have a really solid basis for being there, especially after TC Heartland.
Right. I would agree. But I think what Eric was saying about the judges in Texas, both the Eastern and Western District, still really they're just more likely to get you to trial both in a timely manner and to give you that chance to go to trial, where we see a lot of judges in other districts just being a little more heavy-handed and acting as a gatekeeper, and really slashing some of those damages theories, maybe being very strict on Daubert, and having those very early 101 case dispositive types of rulings, whether in Delaware you have your 101 day that might come in the first couple months. So it is, depends how you look at it. Certainly, you might get some judges in Delaware, Northern California, that if you aren't sure of a case and you don't want to invest all the way to go to trial, you might file in Delaware or Northern District of California, and you're going to have a very smart judge look at, say, your 101 issue. And if you get past that, then maybe you will get a settlement. Maybe you won't have to go to trial, because that's going to be a very solid decision that will be well respected by the Federal Circuit, and will hold up.
So Elena, let me take this a little further. You're in Texas, I believe, and we're speaking a lot about Texas, and you're a funder. So how do you look at this when someone brings a case? Maybe they can file it in Texas. Now you're indicating there's nuances between Eastern District and Western District. It could get transferred. There's all sorts of issues the CAFC might see. So how do you deal with that as a funder when you're looking at a case that maybe it could go to Texas and maybe not?
Well, first of all, Texas is not the be all end all, even though I'm a Texan and I personally lean that way, Texas or nothing. But there are many other venues that we feel very comfortable that a patent plaintiff will have a really good shot with juries, and where the judges, as Christine was saying, are smart, know how to handle patent cases and know how to handle them relatively efficiently. I mentioned Delaware earlier. Eastern District of Virginia as another rocket docket that's a popular option, and Florida and Washington State are getting traction, and Christine mentioned the ITC. So it's certainly not Texas or nothing for us. Second, venue is really obviously just one factor that we're considering when we're evaluating a case and making a funding decision. It's certainly an important consideration, don't get me wrong, but a strong case on the merits is a strong case on the merits. Damages are damages, kind of regardless of where where the case is filed. Conversely, filing a weak case in the Western District, as we talked about, may help you stay in the game longer, may get you to trial, but it's not going to transform a weak case into a strong one. And we're always thinking about the federal circuit at the end of the day, because the defendants certainly are.
Well, Elena, that's a very pragmatic answer, and one I would expect a funder to have. So I thank you. But Christine, let me ask you, as a litigator, if a client comes in, let's say with the funding, so they're in this alone, and what's your advice going to be in terms of Texas versus Delaware? Of course, we're doing this in the abstract, but is it any different than Lena's analysis?
No, I mean, I think a good case is a good case. If you have a solid basis to be able to stick in Texas, then, it's a great forum. You have experienced judges, you have good juries. It's a good forum across the board. But I think it is, and I don't think we haven't seen Albright's sort of post-trial motions get appealed and all of that filter up through the federal circuit, certainly. But the Eastern District has a solid reputation. I mean, you're certainly going to want to be careful. You perhaps might litigate that case in Texas a little differently than you would in Delaware or California or any other district. But, that's sort of par for the course. We consider all sorts of districts, especially now with TC Heartland giving you really, maybe fewer choices and some you wouldn't have considered before. But, Southern District of Florida is a fantastic forum. They are incredibly fast. If you can get jurisdiction down there, it can be a great case to have there.
Well, it sounds like some of these forums are evolving. Is there, how's the body of statistics on the CAFC versus these various district courts? Are there enough statistics, or is this presumably, and my sense of it is that it's always an ongoing, if there are statistics, you're talking about a few dozen cases, and it's hard to make much. Is that correct, or could you shed some light on that?
Yeah, especially once you get outside of a super busy docket. You can get those statistics for broken down any way you want, judge specific, district specific, but sometimes you get one for, a district that isn't very popular in patent cases. And, it's like, oh, well, looks like we have 100% chance because there was only one patent case. They won. So, you have to look behind those statistics very carefully and see what kind of case was this? Was this a competitor case? What kind of case was it? So, I think those statistics have some limited real value once you start getting into these districts that are a little more touch and go. And the judges, how many judges are there? And, some districts, some of the districts in California have some really experienced, solid, patent experienced judges, but then they have so many judges, your chances of actually getting one of those maybe isn't so great. So, it is a complex analysis.
Well, I'm comforted to know that you base your statistical analysis. There's a grain of salt with the statistical analysis that you do. I think that's a good thing. Okay, I'd like to thank you and move to the next part of our panel, which is question and answer portion of the event. At this time, I'd like to invite the audience to ask questions. There's several ways you can do that. You can type questions into the Q&A box, not the chat, but there's a special Q&A box where we'll bring those to the panelists. Or you can raise your hand using the icon at the bottom of your screen, in which case I would ask you to remember to have your video and audio enabled and please state your name and organization, and most importantly, your question when I bring you on stage. So please feel free to submit your questions. In the meantime, we'd like to keep going. And let me throw a question out to the panelists while we amass some questions. There's been a lot of commotion and discussion regarding COVID vaccine patents. At least there was a few weeks ago. Vaccine diplomacy may have pushed that issue to the side. But I'd like to just throw that out there for you. What do you think about that? And perhaps the bigger question as to the current administration's view on patents, and even, dare I say it, the possibility of patent reform and maybe some clarification in some areas like 101. Anybody want to take that? And I will go ahead and bring some other folks up with their questions.
I'm happy to weigh in on the type of patents that I know absolutely nothing about, which is pharma patents. The only thing that I'll say is that at the end of the day, my understanding is we're going to donate 500 million doses of medication around the world. And I dare say that's going to get people vaccinated, at lightning speed as compared to let's waive patents, then build factories, then source materials, then train people, then manufacture, and then see if we can get it into people's arms. And so if you really care about saving lives, forget about the patents and go inoculate the people that need the vaccine. I think the patent argument has been a bit of a fig leaf and an opportunistic argument made by people that would just as soon see the patent regime in the United States weakened across the board. And this was just a chance to throw shade on patents.
Well, thank you. Thank you for that answer. I've got one person ready to come on stage, but in the meantime, as I get ready to do that, let me ask a question that has come in. I will reveal the source. It's a well-written question from Russell Binns, the CEO at AST. And Russell asks, I asked this half jokingly, but for those that are fans of the Constitution, there's a right to a jury trial and right to a fair trial. Does that present a constitutional conflict in patent cases? Juries can often be scary with complex cases. Which is a very good question.
I'll just answer from a funder's perspective. We're certainly not looking for a jury trial necessarily. We're looking for a resolution and one that's as quick as we can get it and as favorable for the party we're funding as possible. I think the benefit of some of these courts that allow cases to go to juries is that the threat of that scary jury it works both ways. It can be scary for plaintiffs, but it can also be a real pain point, fear point for defendants that can get them thinking about settlement in a much more serious way.
Anyone else want to comment on that?
Yeah, and I would just chime in as a litigator. I mean, while I really focus my practice in patent cases and I like to just stay in IP, I mean, when I talk to my friends who do, complex antitrust or complex environmental, I mean, these other cases that are going to juries, I mean, they're crazy. I mean, I feel like our job is we can boil down a patent. I have to explain my cases to my children. So I have to figure out how to explain that technology before we get to trial. I think there are even more complex cases that are going to juries all the time.
I would just say those same juries vote for president. So yeah, it's complex, and that's our system.
Well, those seem to be good answers to this question that does not have an answer per se. I've got a couple of other questions. Let me see if I can bring this up to the panel. I've got one from Robert Heath, the Executive Vice President at RPX. For the financiers, have you ever passed on an investment opportunity because you didn't believe you could keep the case in your preferred venue?
Since I'm the financier on the panel, I'll answer that one. I don't believe that we have passed on an opportunity because we were concerned about the ability to keep a case in a particular venue. We are always going to be analyzing the worst case scenario for that case. So if there's something that makes us truly uncomfortable about where that case could land in the event that it is transferred or dismissed, then that's something we're going to take very seriously. But I think for the most part, it's really just one factor, and I don't believe it's been a deal killer in any of our cases that we've been presented with.
Thank you. I think we have someone coming on stage. Our staff is going to bring one of the participants up to ask a question. Karmanya Singh is an attendee.
Hello.
All this new tech. Once we've mastered this technology, we're going to be ready to meet in person and go out and drink afterwards. Karmanya, it's good to see you. We've got this working, so welcome,
Yes.
and please go ahead and state your company and your question.
Yeah, so I'm from Comet here in Delhi, actually. And my question's for Elena and Christine. Are there any strategies that you've discovered during COVID in all of the chaos that may have ensued, and which have provided an advantage for you, or something that will continue from now as we go beyond COVID?
That's a great question. And my answer involves the way that we structure our returns. And it's kind of a practical response that we've had to the unexpected delays in COVID. We now typically will include a provision in our agreements that allows for a bump. Usually it's a pretty modest bump, but it's some bump in the returns should the case linger, let's say, beyond 48 months. So that's kind of a practical response that we've had to the delays and how we've tried to manage that going forward.
I mean, I would say from a litigation perspective, it's been probably more on the nuts and bolts. Like Zoom depositions are amazing. I mean, just a sort of huge savings of time and money. Although the court reporting services, they take their cut of the savings of the Zoom depositions, but not having to go get on a plane and fly someplace and then rent a car and bring my documents. There a lot of this video conferencing deposition technology was available and was out there, and a lot of us had used it kind of occasionally for some random witness. But now, I mean, I think you're going to see that being used a lot, and I think judges are a lot more conscious now of the burdens they were putting on lawyers to, go fly to California for what turns out to be a 20-minute status conference.
Right.
I mean, those
certainly a lot more efficiency. I mean, I think there's a theory that says COVID, the pandemic, is going to increase efficiency all over. I mean, it's happening. It's happening. I mean, it's causing supply chain issues, but it is increasing efficiency, and that is a good point. We have another question. Can we bring a question up from Louis Carbonneau, CEO at Tangible? A colleague of ours who I know Louis pretty well, and I'll read the question and I think we'll put it on the screen. Here we go. As a funding entity, and so Lena, I think this is directed to you. Do you have a current threshold as to what recoupable damages need to be present before even considering a case on its merits? And has that changed during COVID?
Well, that's a great question. And obviously, damages, case value is important to a funding decision. It kind of has to be front loaded when you're having a discussion with a funder about the case. Our business, we typically are investing a minimum of 1.5 to 2 million and on up in a case. And that's not a hard and fast rule, but that's a pretty good basis for our minimum investment amount. And then we like to see that there's going to be approximately 10 times our investment amount in likely recovery, likely recoverable damages or settlement money in the case. And the reason for that is not that we want to be able to take more, but that we want to ensure that everybody has a healthy expected return at the end of the day. And so that means the lawyers, the funder, we want to make sure after that apart from those getting paid, so apart from the funder and the lawyers getting paid, that there's still significant recovery left for the claimant. So we always want to target 50 to 60% or more being left for the claimant, but
Good.
that requires there to be a really significant amount of likely damages when we're talking pretty hefty investment amounts sometimes.
Thank you. And with that, I think it's time to go to the next portion of our program. I'd like to thank all our panelists. A fascinating, in-depth discussion. Thank you for your time and your preparation. And I think Wendy is going to come back on and bring us to the networking portion. Wendy will give us some information as to how we can do that networking.
Thank you, Charles, and a big thank you to our panelists and our audience members for such an engaging and insightful discussion. Thank you so much. Now we're going to transition to the lounge where we'll have a chance to connect with one another. When you get to the lounge, which is actually where you might have first landed when you came into the platform, you'll see two options. You can either select speed networking up top, where you'll be automatically matched for 3-minute speed meetings, or you can, below that, join a table. And today we have the table set up where you can start off at your appropriate last name table, tables 1 to 5. And you can start there, and then after that, if you'd like to move on to any of the other topic or theme-based tables, we have one that some of the speakers will be at. I see a lot of questions that we didn't have a chance to get to, so if you want to chat with any of the speakers, feel free to sit there. You can actually hop from table to table or go from speed networking to tables and vice versa. So feel free to make your way around the lounge, get comfortable, say hello, catch up with colleagues. Just make sure that you have your audio and your video on for the best networking experience. If you prefer audio only, that's fine. In fact, you'll actually see a table for that in the lounge called audio only. So before we head over to the lounge, I'd like to just take a moment to thank Charles for moderating today's terrific discussion. Thank you to our speakers once again. I'd also like to thank our sponsor, Validity Finance, for making this event possible. And last but not least, I'd like to thank all of you guys for joining us today. Our next event is on July 13th. We're hosting it in collaboration with Women in Litigation Finance, and we'll be discussing the important topic of advancing women leaders in law. So we hope you'll join us for that. And with that, I'll transition us all to the lounge, and I'll wish you all a happy networking session. Oh, one note, this actually ends at 3, but we're gonna keep the lounge open until the last person leaves. So feel free to hang out in the lounge and just enjoy yourself. Thank you.
Thanks. Thank you, Wendy.
Thanks, everyone.